Okay, well, good afternoon, everyone, and welcome to another edition of the monthly Mortgage Law Today show. I'm Brian Levy, the host of the show, and we're joined by our regular panelists, Loretta Salzano and Marty Green, with our sponsor, Polunsky Beitel and Green. We're very fortunate today to have two guests. We've got Kitty Ryan from the ABA. Kitty really has pretty much done it all in the legal world. I was looking at her resume and was just completely blown away that there's nothing she hasn't done. From working for the Fed, working for the CFPB, working for the Department of Justice, having started at the Department of Education even. So she's been in many legal, regulatory, and fair lending related positions, and she is now the Senior Vice President for Fair and Responsible Banking at the American Bankers Association. She is joined, or we are joined by also Paul Hancock, who also has tremendous experience in Washington, having worked for something like 27 years with the Department of Justice in the Civil Rights Division, led fair housing and lending initiatives there, and is currently with the law firm of K&L Gates. So as many of you know, the American Bankers Association recently issued a white paper that Paul authored, and it relates to fair lending. It relates to the constitutional concerns with how both the Department of Justice and the CFPB have been interpreting the fair lending laws in connection with redlining initiatives. And what I'd like to do, after I thank our sponsor again for sponsoring the show, is to ask Paul and Kitty maybe to give us a little bit of what is the constitutional concern with the racial balancing that the fair lending redlining initiatives of the enforcement officials has created this constitutional issue. Maybe if you could summarize that and give us a little flavor of the white paper, I think that would be helpful. And then we'll jump into some questions.
I'll let you start on that one.
Okay, all right. So it's long been held that any effort to use as a method of enforcing civil rights law a requirement for racial balancing is just unconstitutional. It was the Supreme Court said it most recently in the higher education case involving Harvard and North Carolina, where Justice Roberts' opinion says it's just patently unconstitutional to require racial balancing. But that's really not anything new. It goes back many decades to the same thing was said when school desegregation was being done. You can't have a requirement for racial balancing to desegregate schools. It was said in connection with voting rights. In reapportionment, you can't demand a racial balance. It was said in connection with employment, you can't measure discrimination in employment by failure to achieve a racial balance. So I don't think there's any question that racial balancing in enforcing civil rights laws is unconstitutional. Probably the other question though is why are we saying that the government has been applying a racial balance test in connection with redlining? And I'll give you an example of this. I'll complain a little bit about the government's approach and to show why it's a racial balancing test. The way the government, there's a lot of flaws in the approach to redlining. The gravamen of the complaint, though, is what the government calls its proportional distribution test. And that really could be also described as a failure to achieve a racial balance test. What the government does is look at, using HMDA data, look at the totality of all loans made in any metropolitan area in a given year, and look at what percentage of those loans are in minority areas. That becomes the racial balance. So perhaps if you look at a particular metropolitan area in a particular year, that 20% of the loans made by all mortgage lenders in that year were in minority communities. So what the government does in enforcing redlining is to say that if you, the target lender, doesn't achieve that same racial balance, if your percentage of loans in minority areas is substantially or significantly less than that, then you're redlining. That's the gravamen of the complaint. So the flaws with that are, one, it starts with a racial balance. So it's demand for racial balance, so it's unconstitutional. But also it really doesn't make any sense. The test, as I said, is based on the percentage of loans in minority neighborhoods. And that percentage is determined both by the loans, the number of loans, the loans made in minority neighborhoods and the loans made in white neighborhoods. So that a lender theoretically could remedy redlining just by making fewer loans in white neighborhoods. So they could get their percentage of minority loans up by making fewer loans in white neighborhoods. And the test applied doesn't measure service to the minority community. It measures both service to the minority community and to the non-minority community. So under this test, a lender, for example, I gave the example of if 20% of the loans made by all lenders in the metropolitan area were in minority neighborhoods, and a particular lender that's being targeted had 15% of their loans in minority neighborhoods, that lender might be accused of redlining. But that doesn't measure the service to the minority neighborhood. That 15% could be a greater number than most of the other lenders who make loans in the area, simply because not because of the failure to make loans in minority neighborhoods, but because the lender has a predominant presence in non-minority neighborhoods. So
Paul, if I can just jump in for a second, in our conversations prior to this webinar, you sort of bristled at my characterization of this issue as disparate impact, but I think that is very popular in the press and commonly used. How would you distinguish what you're calling racial balancing from disparate impact?
Yeah, it's a good question, Brian. And disparate impact is really at the height of fair lending discussion. So everything that's talked about is talked about in the framework of disparate impact. The Fair Housing Act does recognize the disparate impact legal theory. The Supreme Court said so in the Inclusive Communities case. So claims can be brought using the disparate impact approach. But some types of claims, just by their very nature, involve claims of intent. Redlining is one of those. Redlining means drawing a line around a neighborhood based on its racial composition and saying you're not going to do business there because of its racial composition. That's intent. So and the government has always said, historically, I mean, the first redlining case I brought when I was with the government was in 1994 against Chevy Chase Bank in Washington, D.C. That we presented what we believe to be egregious allegations of intentional discrimination, instructions to loan officers not to do business in certain areas of Washington, D.C. That's intentional discrimination. So over the years, all the guidance from the government on redlining has said redlining is a case of intentional discrimination. The interagency fair lending examination procedures say redlining presents a case of disparate treatment. That's a form of intentional discrimination. So while I think our white paper addresses the disparate impact issue, primarily because in the Biden administration, they began to fudge the complaints more. You know, they said they're making allegations of intent, but they also included kind of typical allegations of disparate impact. So it was not really clear what their theory was. But I think it's beyond dispute that redlining is a claim of intentional discrimination. Then the question becomes, how do you prove intentional discrimination? What constitutes intentional discrimination? And that's where we get to the test that the government applies.
Great.
If I could just jump in, I think some of our members' frustration comes from the sort of dissonance between the exam procedures and everything that all of the agencies always say. Redlining is disparate treatment, redlining is intentional discrimination, and the exam procedures say things like, you know, you can't bring a redlining case just based on statistics. But when you read the language of some of the complaints and just the heavy reliance on this proportional distribution test, I think for our members, it's sort of, well, which is it and what is it and what do you expect of us, right? And to some extent, sometimes it feels like you expect us to achieve this perfect balance, which, you know, as we point out in the white paper, there can be a lot of reasons why we aren't in perfect balance, and the way that the government is approaching this, it sort of seems like there will always be redliners, because you'll always have some banks, some lenders who may fall at the bottom of this sort of ranking of lenders based on the proportional distribution test, and that just doesn't seem to make sense.
So
Well, you
was
may
it
have just
that
answered. Go
outcry
ahead, Laura.
from your members that caused the ABA to decide what should we do? Or because there are lots of things that members can do when they're displeased. And it's curious to me how this came about. And I know, Brian, that's something you were contemplating as well. Do you mind sharing that?
Yeah, no, and I guess maybe also if you could address, Kitty, it's pretty apparent that these issues pose public relations issues for banks in terms of fair lending issues that can be very sensitive in people's views of that. I'm so curious as to not just sort of the issues that you raised with examinations and frustrations with that process, but also just the internal, what you can share, discussions around the broader societal issues, I guess.
So, of course, banks are they're not set up to discriminate against people. They want to make credit available as broadly as they can. And they have obligations under the CRA to serve their communities, help meet the credit needs consistent with safe and sound operations, right? And so, they start out in that posture. I don't think I think it's fair to say the decision to write the white paper wasn't taken lightly. We're certainly aware that there can be a perception that, oh, if you're complaining about the government's approach, then you must be doing something wrong. You must be trying to hide something. And that's not the case at all. But certainly over the last 4 years, and really going back longer, I've heard a lot from banks, particularly community banks, that, as I mentioned, were frustrated by this and surprised, I think, in some ways quite unfairly, by suddenly being tagged with redlining. Paul mentioned the example of a bank that might be actually making more loans in Black neighborhoods than some of their so-called peers. That's a whole nother conversation in and of itself, but let's assume they really are a peer. To a CEO, they sort of scratch their head and say, well, why does the government think I intend to avoid Black neighborhoods if I'm actually making more loans there than some of the other lenders who happen to rank higher or better on this list because of that proportional test? So, there's a sort of frustration that was building up about that. We could delve into other areas of the government's approach to redlining that are frustrating, but I think, the proportional distribution test, the sort of surprise, hey, you're redlining, particularly where the bank may have been examined, a year before or 2 years before or 3 years before and told, no, everything's fine. Nothing's really changed for that bank. And suddenly they are told that they have a redlining problem. And of course, there is this interplay with Community Reinvestment Act. And while that sort of looks at the banks lending across the income levels of neighborhoods, we all know in most MSAs, not all, but in many or most, low and moderate income is going to overlay with minority neighborhoods. So if a bank gets a satisfactory CRA rating or even an outstanding one, and then sometimes it is the same regulator, it might be the prudential regulator that has examined them for CRA and has said you're satisfactory or you're outstanding, then comes in a year later and says, but you have a redlining problem. That's like having a bucket of cold water dumped on your head, and it is very difficult to sort of work through this. And particularly if it does get to the point of a public enforcement action, the reputational hit is enormous. So, there are a lot of reasons for wanting to get the white paper out there, explain to maybe a broader audience how the government is approaching this and what we think are the flaws in that approach.
Let me emphasize the numbers issue because I really think it's critical here. The government has just refused to consider, at least in the last administration, refused to consider the number of loans that a targeted lender made in minority neighborhoods and how that compares to other lenders who have made loans in the same geographic, in the same metropolitan area. And lenders they have sued are sometimes the largest originators in minority areas. That just doesn't make any sense. You're alleging redlining, which is a failure to originate loans in minority neighborhoods, and yet you're suing a lender that makes more loans in minority neighborhoods than an overwhelming majority, up to 95% of all the lenders who have made loans in that area. That just doesn't make any sense. It doesn't make any sense from a legal perspective. It doesn't make any sense from a policy perspective. Why would the government want to label a bank as racist when it is one of the largest originators in the minority area? Now, the other thing we have to consider with this is that there's never been a redlining case that's been litigated. It's always been
Settled? Always settled?
every one of them has settled because it's a terrible allegation against a lender to say you're a racist bank, you won't make loans in minority neighborhoods. And we're seeing now the new administration pushing back on some civil rights issues in a manner that the earlier administration did too, in that if you have the claim outstanding, you're going to be prohibited from branching, you're going to be prohibited from expanding, you're going to face issues with your regulator. So every single case that's ever been filed has been settled by a consent decree. So that just means that redlining is whatever the government says it is. And it's a slippery slope. The government has great power. They can put great pressure on institutions that they target. So we've had this kind of slippery slope from when the beginning of redlining cases really relied heavily on egregious examples, whether they're true or not would have to be proven, but at least the complaints allege egregious examples of intentional discrimination, instructions not to do business in areas where minorities reside, to where we've come today, which is you don't have the same racial balance that the majority does. So that's the basis for the redlining claim.
Paul, one of the
that's a
questions
precipitating cause. Oh, I'm sorry, Brian.
I was just one of the questions in the chat was about the Fairway case being an example of what you're talking about, that the largest lender, or at least they claim to be the largest minority lender in the area, yet their proportional numbers were beneath what the government wanted, so they still had to deal with the consent.
Yeah, and that's a good example, Brian, because Fairway is the example where, and Kitty mentioned that the government, I've given the example of all lenders, the government tries to examine who they believe your peers are and how you compare to your peers, which is a really arbitrary number. The government claims a peer of a bank is any bank that, or any lender, not bank, any lender that had a loan volume or application volume that's between 50% and 200% of the targeted lender. So they've often list as peers, a small community bank, like Kitty mentioned, might have it as its peers, Wells Fargo and Bank of America and Rocket Mortgage, that have little in common with them. So there's a lot of flaws there. It's just really nonsensical. And Fairway claimed, and I don't know if it's true or not, but Fairway claimed in its press release when it was sued that it made a greater number of loans in, I think it was the Birmingham area, than any other non-bank lender that had a presence in the area. So if that's the case, it's not clear why the government would ever think that's an appropriate lender to charge with redlining.
Well, I want to play a little bit of devil's advocate here for a second on the question of intent, which I think is maybe fundamental to your white paper thesis. And I think I guess I would ask, what would you say to the people who say that structural racism reflects the intent of that you're looking for, that you can find it in the outcomes reflect structural racism, and that reflects the intent? how would you argue against that?
Well, I mean, we know we have a history of racial discrimination in the United States. That's not disputed, but that history can't be the basis for suing someone who's not responsible for discrimination. Again, that was considered in the higher education case where the question was, there's a great disparity in backgrounds of minorities and non-minorities, but that doesn't permit you to give a racial preference. You can give a racial preference if it's a remedy for past discrimination, but the remedy has to be focused on the people who were the victims of that discrimination and to remedy the injury to them. So I don't know if that answers your question, Brian.
No, I think it does.
Oh, and do you feel like, and that's why I was curious when we're looking at these cases, and we know the government starts with the data analysis. That's something that any lender, not just the banks that are part of the ABA, have to deal with. But we've seen through Townstone and through Trident that if there's some negative email or what are perceived to be racist comments, which some people even dispute what's a racist comment, but if there is some kind of a smoking gun, then is it the smoking gun that starts the investigation also, where then maybe the government will look at the data and try to back into a claim of intentional discrimination because it might be easier to prove than demonstrating other evidence of intentional discrimination? Is it always the cart and the horse, or the horse and the cart?
Well, right. I think they start with the numbers. They do analysis based on HMDA data. So they pick their targets based on the number and the deviation from the required racial balance. The more you deviate from that. And a typical target, Kitty mentioned, is a community bank. And a community bank might have started in a suburb of a metropolitan area and got a great footing there. They do a lot of business there. And then they began to expand into other sections of the MSA, including minority neighborhoods. But because they have an overwhelming presence in white neighborhoods, their balance is off. And that becomes the claim. The government then, and particularly in more recent years, has been looking for other evidence of discrimination and likes to find emails that indicate discrimination. Some of them are disturbing, but the question is not whether somebody has said something bad. The question is whether they're refusing to make mortgage loans based on the racial composition of the neighborhood. And a lot of times the government just seems to assume that link. If you find a bad email, that means that you're redlining. Well, you've got to, other things that I think you were alluding to, the government also talks about, they emphasize a lot about branch locations where a bank has branches. And, that goes back to the original redlining case against Chevy Chase Bank, where Chevy Chase claimed that one reason it wasn't making loans in minority areas was because it didn't have branches in those areas. And so it over the years, though, branches have become less integral to mortgage lending than they were 30 years ago. People today don't go to a branch most of the time. To who here has gone the last time you've been to a branch? So
and especially with IMBs, where these laws are being applied to IMBs the same as to banks, where the IMB has no other products and services to offer.
Yeah. And the government has data under the data about the method of application for applicants. So they could see how frequently an application is taken by phone, how it's face-to-face, whether it's in the branch or not. But they won't consider that. They just assume that if you don't have enough branches in their view in minority neighborhoods, that indicates you're redlining. Now, branches, again, the link has to be to mortgage lending, not just branches. Branches, for the most part, don't offer the types of products that are even covered by the Fair Housing Act. They offer checking accounts and savings accounts. That's the important part of bank. Those aren't even covered by the Fair Housing Act. So the government has to show that somehow branching has an effect on mortgage lending. And generally they just assume that. They don't attempt to prove it.
And that's what's interesting, I think, Paul, is just that it seems to be an antiquated theory in some ways, and certainly the remedies that they have in certain instances requiring branches, which in many instances aren't even manned by people anymore. I mean, loan officers don't even go into the branches in a lot of instances anymore on the IMB side for sure. So it just seems to me that the theory is somewhat antiquated, and especially as it applies to IMBs. And you mentioned this in the Townstone case, Loretta, that's one that it struck me that it was really the radio show that led to the complaint in terms of them looking at the data more deeply than it would have been otherwise. I don't think they would have been on the radar otherwise, but
Right.
the whole
Yeah,
theory.
because they're so tiny too.
That's what I was saying is, yeah, it's
Yeah.
hard for them to think of I joked about that. It's not really a red line, it's a red dot. They were so small.
Yeah, I want to stick on this point about remedies, Marty. And I just want to make sure that I maybe have forgotten to tell everybody that this is not legal advice. Nobody's giving legal advice on this call. We're just information here, infotainment, whatever you want to call it. The question I have is, and I think this particularly relates to the topic that I'm about to raise, which is in terms of the remedies that they've been imposing in the consent orders, opening branches, requiring marketing, very dubious as to whether they're effective to accomplish the objective. But the one thing that I know goes into just about all of the consent orders is the special purpose credit programs. And I know your white paper talked about that. And I think that in particular can raise the same kinds of issues that you're raising in the white paper with the constitutional questions. And I guess I'd like to give you a chance to talk about that.
Sure. So I would separate that just a little bit because the consent decrees often require special loan programs. And the question is, those are preferences. The justification, the government would say its justification for that is that it's a remedy for past discrimination, so it's permissible under the Constitution. To the extent it is, now that raises a lot of issues, whether it is a remedy for past discrimination. And as I said earlier, generally remedies for past discrimination have to address discrimination by the defendant, the bank that's been sued. Has it discriminated? Who was a victim of that discrimination, and how can you remedy the discrimination to that victim? So the remedy that the government generally gets in these cases is not limited to people who didn't apply because of redlining. It's given to everybody, every minority that lives in the area, and sometimes even every non-minority that lives in the redlined area. Now, special purpose credit programs raise another issue, and it's an important one, is that our special purpose credit programs themselves valid because they have they give a preference. The argument in favor of special purpose credit programs is they're authorized by the Equal Credit Opportunity Act in Regulation B. I think there's still a question as to whether some particular types of special purpose credit programs would pass legal muster, and particularly those that give racial preferences. The special purpose credit program is authorized by the Equal Credit Opportunity Act as a way to meet special social needs. That's the language that's used. So the question becomes, is race by itself an important social need? The Supreme Court in the higher education case said no to that. So, we haven't had yet the fallout yet about how that applies to special purpose credit programs and what it's going to mean in the future for special purpose credit programs. I've always cautioned my clients to beware of credit programs that are race-based. Don't say minority, you get a special loan because you're minority. As Kitty said, you could do it on income status, social economic status, and that in most areas of the United States greatly overlaps with race. So a lender that wants to have a special purpose credit program to provide special terms to people living in low and moderate income areas, has a better claim that's lawful than a lender that says we're going to make a special rate for minorities.
Yeah, I just have to chime in. I do see the loan programs under the consent decrees as different from a special purpose credit program under Reg B, under ECOA, for the reasons Paul said. I think what the government is doing in the consent decrees is, attempting to require the bank to remediate, as opposed to a bank decides or a lender decides to, offer a program for first-time home buyers who want to buy a home in lower moderate income areas, and they follow the rubrics in Reg B. It seems to me that's fundamentally a different thing, even though they're both attempting to address inequities and some of the problems that continue to haunt us about low home ownership rates.
Yeah, and the
Thank you.
slippery slope here has led to some of the more recent ones in the last administration, even provided that a special rate for people who live in the targeted the allegedly red line area, but want to buy a home in a non-minority area. So I don't know how you could say that remedies if the claim was you discriminated by not making loans in minority neighborhoods. How do you remedy that by saying you've got to let somebody buy a home in a non-minority area? It just doesn't make sense.
And there are concerns about the special purpose credit programs when they are geography based, especially when there's gentrification, and who's really going to receive the benefit of the program, and is it going to fix what you're trying to fix? So, I like the idea of the slippery slope in so many ways, because we think about how this legal argument has expanded from access to credit versus, or like refusing to make loans to people versus access. And if you have limited resources, how are you going to allocate those to have it make economic sense to keep your doors open while serving everyone you can? And then this idea about just looking at numbers, it's not really where the law is, as you said.
Right.
And
The
how do we
government,
know, or how do your members know at any minute what they're charged with doing as responsible banks?
so I could describe the slippery slope, how it's gone over the years. It started with, and I think it still is, the proper definition of redlining is a refusal to make loans in a geographic area because of its racial composition, not in spite of, but because of its racial composition. Over time, when they couldn't find evidence of intentional discrimination, they changed the meaning to failure to provide equal access. That's the term that was used more recently in the Biden administration. And equal access fits their definition of racial balance. The starting point is a racial balance. And if you're not meeting that racial balance, you're not providing equal access to minorities. And that's where I think fundamentally that's wrong. Fundamentally, I think that's unconstitutional. And as I said, it's inexplicable to me that the government doesn't focus on how many loans are you making in minority areas, and how does that compare to other lenders who have made loans in the area.
Great, thank you. Kitty, I'd like to maybe shift a little bit to what is the ABA going to do with this white paper, and how are what is the next step for advancing the policy issues?
So the white paper, towards the end, if you got all the way there, does make certain asks, right? And in part, it was directed to the Department of Justice to rebalance itself. We keep using this word balance, but part of it was to bring all of this to light, set it in front of the leadership, and to say there needs to be a recalibration to think about the department's role. As Paul points out in the paper, they're supposed to implement the law in a fair and even-handed manner, but it seems as if over the decades they sort of drifted into an advocacy kind of role in the way that they approached redlining, and really stretched what redlining is in a way that I think is not legally correct and raises other problems. So in part it was to bring it to their attention. We also call on Congress to sort of emphasize that redlining is intentional discrimination, and direct the agencies to operate in accordance with their exam procedures and the other guidance that says that it's intentional discrimination. And then I think there's also a request that really the agencies and the industry could work together to, kind of hash this out, decide this is what redlining is, and obviously we think it's intentional discrimination. And to some extent, although it's not in the paper, we've talked about the inequalities and the issues that just seem to live on in this country. It seems to me there are other productive things that we all could be doing to try to address those inequalities, rather than the government looking at some statistics and singling out a random bank to then hold responsible for things that it's not responsible for, or in the case of Townstone, hearing apparently some language it didn't like, and then, bringing all of its enforcement resources to bear on that very small lender. If we're really serious about addressing these issues, this is not the way to do it. I'm not sure that I have the answer of how to do it, but I think that, there's always the opportunity to sit down and try to reason together on some strategies that might be helpful, whether it's special purpose credit programs or it's something else. It's, putting more money and more emphasis on community development, job creation, supporting small businesses so that they can create jobs that will then, enable people eventually to buy a home. I think there are other ways to address the underlying inequities, and that this sort of approach isn't tremendously helpful. Just my opinion.
Well, so we've had the Trump executive orders on DEI, which at least from the executive branch perspective, seem to put a complete kibosh on the kinds of concerns that you're raising. They seem very much in line with the idea that, unless you have intentional discrimination, you don't have a fair lending case. I guess we'll have to see how that plays out. But the problem with executive orders, as I'm sure you both know, is the durability of those is limited to the administration at hand. And so I'm wondering if you have any thoughts on more durable types of change that, whether it's statutory, or whether there's some kind of test case or case that might percolate up, which might challenge some of the specific types of redlining cases that you're concerned about.
Well, let me just say something about the executive orders on DEI, and I think I heard you say, those seem to go against what I was saying. I think it's fair that the executive orders are focused on sort of, special programs, or, giving people special rates or what have you, or employment based on race or other protected characteristics. But when I think about this, I do think more about income and income inequality. So I wasn't really speaking about, hey, let's have a roundtable and decide how to, specifically target Black Americans or Hispanic Americans, but really thinking more about income inequality, because in my view, that's what drives a lot of this. And that's a much deeper issue than, requires a lot more thinking and a lot more stakeholders to address. So I want to make that clear. I've forgotten the rest of your question. So if you wouldn't mind.
It's really about durability of the change.
Oh, durability. Well, that's the holy grail that we all seek to achieve in these days, where we see things flip-flop, right? We have one administration that, for example, the Biden administration took this particular view of redlining, and now it seems we have an administration that is likely not to take that view of redlining. And how do we solve for that? In a perfect world, Congress would come in and settle all of this, but we all know there's a filibuster and there are strongly held views on both sides. So I think, that may be a bridge too far right now, but we can certainly ask Congress to play an oversight role here with the agencies, and we can certainly ask the agencies to consider their own internal policies, build those out as much as they can, and train everybody in the right way to approach these issues. That may be the best that we can do at this juncture. That's where we are.
Okay.
Yeah, at some point, I mean, it's pretty clear this administration isn't going to bring these redlining cases like the prior administration did. In fact, one of the things they've been doing more recently is going to court, asking the court to dismiss the cases that had been filed previously. But private plaintiffs are going to continue to espouse this theory. State and local enforcement agencies are going to continue to espouse this theory. So at some point, I think it's going to have to be litigated. You know, what is redlining? What is redlining and what isn't redlining? Face these constitutional concerns. They've never been raised. The government has never defended its theory for redlining. So I think at some point it's going to have to. It can be through guidance. HUD could give guidance. I mean, HUD has already said it's reconsidering its rule on disparate impact, and at some point we'll probably see something from HUD on that. But HUD has authority under the Fair Housing Act to issue regulations and give guidance, and it could give guidance on this. The Department of Justice could give guidance. Over the years, the Department of Justice has given guidance to the lending industry on what it thinks are appropriate ways of dealing with fair lending issues. It could give guidance here. So there's a lot of things that could be done, but at some point, there's got to be some pushback against the way it's been done to this point.
Paul, do you think there's some risk to a private plaintiff bringing that kind of lawsuit that the DOJ might actually side with the bank or the defendant in the action and actually end up with the government on the other side of that issue, where historically they've been on the same side as the plaintiff?
Yeah, Marty, I think that's possible. They could come in to try to get involved in the case as well.
This administration looks like it would be more likely to do that than.
Yeah, that's right. They might be more eager to do something like that.
Mhm.
Well, we have a few more minutes, and I do get some questions from people that are very concerned about the current state of our legal system, of our government. And I thought maybe we could really pull this up to the 80,000-foot level and ask you two experts, what do you guys feel about the state of the rule of law right now in this country? Are you concerned? Should people be concerned? Or is the system working? I just would love to hear your thoughts on that.
Well, from a civil rights perspective, and I, again, my background, I enforce this law. I believe strongly in fair and even-handed enforcement of fair lending laws. And I think as much the harm is done to the enforcement program, and particularly to the Department of Justice, by policies that go too far in either direction. The last administration went very far to the left, which was really harmful. This administration is going very far to the right, and farther to the right than ever has been done before, which will be harmful to the Department of Justice. And here, now what concerns me is what being done is it's not just every new administration can come in and have their own priorities. What do they want to concentrate on? Do they want to concentrate on religious discrimination? Do they want to concentrate on disparate treatment rather than disparate impact? That's all valid. They can do that. What concerns me now is that this administration has been just dismantling the Civil Rights Division of the Department of Justice, which I think will be very hard to rebuild. So again, I think my view is the government should be even-handed, middle of the road, not too far to the right and not too far to the left, because it just causes the pushback. This administration is pushing back against what they thought to be too aggressive policies of the prior administration. And if we get a new administration, they'll probably push back against these administrations. So,
Well, and
and
you
it's
hear
harmful to
the
the civil rights.
career regulators trying to be effective in that type of environment and warn people, look, this is temporary. And when we do a look back, it's 5 years, or here are all the things that we're still doing. And it's interesting to see today the OCC's, announcement that we're not going to be looking at disparate impact. Now, we're not going to be analyzing data this way anyway. We're modifying our exam manuals. So it is hard for people to know. And you can't make these kind of decisions based on a snapshot in time with someone with a political agenda, especially for your bank clients, big banks, how they allocate their resources, what their policies are. It's a lot.
Yeah, I'll just say the extremes are difficult and the pendulum swings are difficult.
Mm-hmm. Well, and the credibility, if people don't have faith in the government and the processes, and I didn't realize until I read the white paper about this sort of stealth tactics, that we're not really going to tell you what we have, and you're not going to see the complaint, and you're going to try to negotiate a settlement, and then things might not be as you perceive, or then things might be published in a way that you didn't anticipate, and the reputational risk and the scare tactics for everyone else in the industry. You know, I can see the government's agenda, but that's not how people want to live in our country, right? We want more predictability and confidence in the processes.
Yes, turning to redlining, I can't imagine a more invidious allegation than to tell somebody, a bank, that you have refused to do business because of the racial composition of the neighborhood. That's a terrible, terrible accusation. And the standard should be tough. It's a serious charge. The standard should be tough. And if the government doesn't have proof of intentional discrimination, then they just shouldn't bring the case. The case shouldn't be brought just to get notches in your belt, to say how many cases you brought. And as Kitty said, you know, one major flaw in this government approach, the racial balance test, is there will always be cases. They're never going to go away because it's a deviation from the average. And by definition,
Right, someone's got to be at the bottom.
that's always going to
That's
be.
what I thought. Somebody, I mean, nobody, you can't, if you're all looking at proportion, it's
And you
terrible.
don't even know, Loretta, you don't know whether your deviation, as you know, HMDA data comes out a year late.
Right.
So you know
right.
how many loans you made in minority neighborhoods, but you don't know what the total of all lenders is. And then when you find that out, it's, well, too late, you've redlined, so you're going to be sued.
Well,
And
I
then
will
for
say
a
that,
small lender, it's go find 2 more loans. It's only 2 more loans, and someone else is making more, and you know, they're trying as hard as they can, and it's just, it's tough.
Or even worse, don't make so many loans in white neighborhoods.
Right.
You're okay. You're not redlining. If you just
That's the balance.
lower the number of loans you made in white neighborhoods. So the same lender could be charged with redlining and then remedy it by not doing any more in the minority community, but just by making fewer loans in white neighborhood. So this, you know, from a civil rights enforcer perspective, this just doesn't make sense.
yeah. Well, I will say we're all out of time here, and I want to thank our panelists so much for the great insights today. The white paper goes through several examples of the exact kind of calculations that Paul was just discussing. I know it was linked to it in the flyer for the program. I'm sure there'll be a link in the show notes, and I also saw one in the chat screen. So lots of ways to find the white paper. I'm sure you could probably find it on the ABA's website as well. Thank you all again for your participation today. Really enjoyed this conversation, and look forward to seeing everyone on the next third Tuesday of the month. Thanks,
Thank
everyone.
you, everybody.
Thanks, Kitty and
Bye.
Paul.
Bye. Thank
Bye-bye.
you, everybody. Bye. Good to see everybody.